I'm going to start by talking about three fairly basic concepts in EU law that are necessary to understand how the issues work, concepts of existence, exercise, exhaustion, and specific subject matter. These may be familiar to some of you, hopefully not. And then I'm going to look at two substantive issues, one relating to distribution agreements and intellectual property rights. And then I'm going to look at a specific issue, which is copyright licensing agreements and geo-blocking. The last one has both a legal and a political angle to it, and I'll try and explain a little bit the politics of the case law. So, as you said, I have some cases. So let's start with a very old judgment. If you haven't done competition law before and you haven't read this case, then that's the first case you need to read. So we have a manufacturer of radios called Grundig and a distributor of these radios called Constant. So Grundig wanted to penetrate the French market. So in the red box, imagine Grundig being based in Germany. And in the blue box is Constant, the French distributor. And Constant is appointed as the exclusive distributor for the French market. Nobody but Constant shall distribute Grundig radios in France. The obligations under the contract were to provide publicity for the radios and post-sale services. And Constant was forbidden to sell these radios outside of France. You have a monopoly to sell Grundig radios in France, and you shall not sell them anywhere else. On the other hand, Grundig agreed, the red box, not to supply these radios to other distributors in France, exclusivity, and to prohibit all distributors from exporting radios into the French market. So the French market is sealed off, and the only person present in that market is Constant. And to make this even more sealed off, the bottom of the blue box, Constant was allowed to register Grundig's trademark, Grundig International, in France. So in France, Constant is the exclusive distributor who also has the trademark rights to enforce against anybody trying to sell radios in France. The inevitable happened. A wholesaler in Germany bought some radios and tried to sell them in the French market because the prices were higher. And the case began not as a commission decision, but as a private litigation in France, where Constant asserted the trademark and tried to block the sales of radios that had been imported from France. But the commission heard about this litigation and started to investigate the agreement between Constant and Grundig. And this is the first commission decision in competition law of some significance. And of relevance to us today is this assignment of the trademark that Grundig conferred onto Constant. And here is where the court explained that while under EU law, one cannot challenge the grant of an intellectual property right. So the fact that a trademark, Grundig International, exists and that this had been conferred upon Constant is not illegal, European Union law can challenge the exercise of that right. So the first distinction that is important in applying intellectual property law is this distinction the court draws between the existence of an intellectual property right, not challenged by EU law, notwithstanding that EU law is supreme, but the exercise can be challenged. And then later on in the judgment, the court explains that EU law does not allow the improper use of rights under any national trademark law in order to frustrate the community's laws on cartels. And in this phrase, I think what's interesting is the court speaking about improper use. So it's not every exercise of the right which is illegal. It is only those rights which the court decides are improper. And so then what one has to work out is when is it that the trademark holder or the intellectual property holder is using these rights in an improper manner. And in a way, the court's case law since then has been an attempt to try to work out what is a proper and an improper use. So that's the first big concept to bear in mind. Existence is lawful, exercise may be unlawful if used improperly, whatever that means. For the second and the third concept, I'm going to talk to you about a case that came from the Dutch Supreme Court, Dior and Evora. So Dior, you know, is a manufacturer of luxury products, and under its ownership are a number of luxury perfume brands. And the red box is the Netherlands. And in the Netherlands, Dior had created a system of selective distribution by which its perfumes were sold through luxury perfume stores. And Dior retained the trademark over all these perfumes on the Dutch market. Now, if you've ever been to the Netherlands, there's a shop called Kruidvat, which is a sort of pharmacy, sells cheap stuff. And somehow, reaching out outside the European Union, we do not know from where, Kruidvat had obtained a lot of these perfumes that Dior was selling. And in the Christmas of 1997, Kruidvat published a leaflet saying, here are all the good things you can buy from us at Christmas. Socks, underwear, diapers, Dior perfumes. And Dior was not very happy that its perfumes were being sold in Kruidvat stores because the image is completely different from the image of a Dior store. But it was particularly unhappy by this leaflet that everybody was getting in the mail, where there were lots of goods that you could buy, and Dior perfumes were in the middle of a variety of other products that Kruidvat sells, which are of not similar quality to those of Dior. And so Dior brought the owner of Kruidvat, a company called Evora, to court and saying, I want an injunction because I want you to stop selling my products. I want you to stop advertising, and I want damages as well because, of course, you've tarnished my image as a luxurious brand. But Kruidvat said, but I have European Union law on my side. And indeed it does, because of the doctrine of exhaustion. The doctrine of exhaustion says that once the goods are sold anywhere in the European Economic Area with either by Dior or with Dior's consent, then the trademark claim is finished. It is exhausted. You can no longer rely on the trademark claim once the goods have been sold. And so as soon as Evora found a wholesaler who had bought the goods from Dior willing to sell it to it, it could import these into the Dutch market without being worried about the trademark. So the right to exercise your trademark is exhausted upon first sale. Now, at the time these early cases were being decided, there was not much secondary legislation, but now trademark law is partially harmonized at European level. And so the doctrine in Dior is now found in the Trademark Directive, Article 15 of the most recent version of it. And so you see paragraph 1 is effectively repeating what the court has said about exhaustion. A trademark shall not entitle the proprietor to prohibit its use in relation to goods which have been put on the market in the Union under that trademark by the proprietor or with the proprietor's consent. So what the case law created, the legislator then codifies in secondary legislation. But paragraph 2 is interesting because the legislator realized that this principle of exhaustion may not always be the right way to apply European law. That sometimes it may be worth allowing the trademark owner to protect this trademark and so to exercise it in an appropriate way. And so paragraph 1 shall not apply where there are legitimate reasons for the proprietor to oppose further commercialization of goods, especially where the condition of the goods is changed or impaired after they've been put on the market. And so the point of interest, and I'm going to spend a bit of time on this, is on what these legitimate reasons are. But let me just explain why there is a particular example. So there is a general sentence, which I highlighted in bold, legitimate reasons, and then the legislator gives a specific example of one legitimate reason. And the reason for this is simply because of an accident of what happened in the case law before. So there were a number of cases preceding the trademark directive where pharmaceutical companies were selling the same drug in different member states with different packaging. So in the Netherlands, it would be a package of 6 capsules. In Germany, it would be 9 capsules. In France, it would be 16 capsules. So it was the same medicine, but packaged differently. And the reason for the different packaging is that it would be difficult for people to export the medicine from one country to another. And medicines are easy to transport because they're very light. They're a homogeneous product. So if you're prescribed a particular medicine, it doesn't matter which box you get, but the doctor likes to make sure the patient feels secure and get the right box. And so what a lot of parallel traders would do is they would repackage the medicine. So they would buy it cheap in the UK, repackage it to fit the French market, and then sell it into the UK. And which is why the second sentence here, the second part of the sentence reads, the condition of goods is changed and impaired, and that goes to this repackaging. But the court has gone beyond repackaging to explore legitimate reasons. So how do we go about deciding when a trademark owner can use their trademark rights to block parallel trade? And this goes to the third concept, the specific subject matter of the intellectual property right. So you are entitled to exercise your right to prevent parallel trade if this protects the specific subject matter of the trademark or of the intellectual property right. I should say that I'm using two cases on trademarks by coincidence. The same three principles, existence, exercise, exhaustion, and specific subject matter, apply to all intellectual property rights. I'm just using this as just to make it a bit more concrete. So in one judgment, 1996, Bristol Myers Squibb, the court tried to give a definition of the specific subject matter of trademarks, and you can dig through the case law and you'll find different specific subject matters for all intellectual property rights. But the difficulty the court has had is in coming up with a proper conceptualization. So I think in my view, rather than looking at the way in which it is defined here, so for example, here, the guarantee that the products that bear the mark have been manufactured under the control of a single undertaking who is responsible for the quality, one looks more closely at the case law. Obviously, if you look at the definition of specific subject matter, I can prevent parallel trade in counterfeit goods. That's obvious, right? I can say the parallel trader is not parallel trading my products. He's trading goods which are counterfeit, so that's clearly a legitimate reason to block trade. I can prevent the repackaging if the repackaging is in goods with the boxes being of poor quality. So if somebody gets a bunch of perfumes from Dior and then repackages them in, brown boxes which have no trademark on the boxes, then I can say, okay, I don't want those sold because you're devaluing the product. People are buying the box as well as the contents. But then there are some interesting cases that came up at national level which may be worth a discussion. So in this case, for example, Dior wanted to block Kruidvat not from selling the products, but for publishing a Christmas leaflet with a discounted list of goods. And then there's a case from the French courts where, again, Dior, by coincidence, saw that its products were being advertised by a retailer in a catalog which consisted also of a list of non-luxury products, dog food, sugar, fresh pork bellies, peanuts, and cooked ham. Can I block that? And then what about a case from the Tribunale di Milano where the owner of the luxury product, Sisley, wanted to block sales on Amazon? And because he said, look, Amazon doesn't look as luxurious as my online store. And so I'd like to prevent sales on Amazon because I do not feel that the quality of my products is guaranteed. So in all of these three kinds of situations, the national court has to decide what is and isn't an improper use. And of course, this is a question of fact. So this is not a question where one can go to the Court of Justice and ask, please give me a definition of proper and improper use of the trademark. This is something where the court will just delegate to the national court to say, look, guys, this is a question for you to answer, not for me to tell you. So in the Dior and Evora judgment that I spoke about earlier, if you look at Advocate General Jacobs' opinion, he gives some general indications. And the general indication he gives is that the activity of the parallel trader has to be sufficiently serious to warrant intervention. So that if you merely sell the goods at a discount, that is not sufficient. So the fact that the parallel trader sells the goods 50% lower than the price at which they're marketed in the luxury store is definitely not going to be something for which you can legitimately prevent the sale of a trademark. If you take the Spanish case there, that is obviously something where Dior can legitimately insist that I can still get an injunction to prevent the sale of my products because they're sold alongside these non-luxury products. So the Spanish case is, I think, one which is clearly on the side, yes, I can get an injunction. The price example is clearly an example where you cannot get an injunction. But then in between, there are a lot of cases which are a little bit less clear. So the sales on Amazon, the Italian judge says, yes, Sisley can get an injunction to prevent sales on Amazon. And the justification the judge gave was that the Amazon platform does not guarantee that the viewer will observe these products with the same aura of luxury than if he went on Sisley's own website. So he compared the quality of the website that Sisley provided with the quality of the website Amazon provides, and says there is a legitimate reason for the trademark owner to seek an injunction because the quality of the presentation of the products isn't good enough. But this is a question of fact, needs to be resolved on a case-by-case basis. There are some clearly egregious cases, some clear cases, and some that go a little bit in between. The point I want to make is that although the Court of Justice began in the 1960s to say the internal market means that parallel trade shall always be allowed, and an attempt by a manufacturer to prevent parallel trade in goods is illegitimate, there is now an exception, and this exception is legitimate reasons to protect one's intellectual property rights. So there's a bit of a balance between the creation of an internal market on the one hand, which the court regularly pushes, and the desire to protect intellectual property rights, which the court sees as legitimate expressions of business conduct. And so you kind of need to balance these two things. And that's how the court tries, case by case, depending on what the IP right tries to protect. That is why the legitimate subject matter is important, because that gives you a clue as to what the justification is. So I use trademark because the cases are the most fun. But for all of them, you need to say, what is the point of patent law? And can the patent holder prevent parallel trade in order to protect whatever it is the patent wants to protect? And one question, of course, with patents, and I'll come to it when I look at copyright, is profits, right? Can I use my need to make money as a justification for preventing parallel trade? So in the patent field in particular, this is relevant because many patent holders will tell you, I have no reason to believe that they're right or wrong, but they have paid many economists to say this, so whether it's true or not, that they need a lot of revenue in order to invent new medicines. And therefore, parallel trade in medicines, where the medicines go from expensive countries to cheap countries, reduces their profits to such an extent that they need to protect their profits they need to prevent parallel trade in order to protect their profits, in order to achieve research and development. So there is some case law where the Court of Justice has said, yes, it is possible for you to make an argument that blocking parallel trade in medicines is necessary for you to make enough money to invent, but the burden of proof is on you to demonstrate that you need this profit. And this is the same in competition law cases, where in 2009, the Court of Justice, in the case about GlaxoSmithKline was trying to prevent parallel trade of medicines from Greece to the UK. So the parallel trader would buy the medicines in Greece, which were very cheap, sell them in the UK where the price was much higher. And one of the arguments GlaxoSmithKline made is this profit loss justifies me imposing a restriction on competition because by reducing my profits, I have less money to invent new medicines in the future. And the court, on the facts, said, you haven't proved it, but as a matter of theory, it's possible. I'll come back to this point later. Now, one thing I want to think about a little bit is we have these cases on trademark law where what I've shown you is that the holder of the trademark or the person to whom the trademark is assigned can assert the trademark right. But let's think a little bit more about the way in which a brand is managed and the laws to which a manufacturer of branded products is subjected to. They're subjected to, they have trademark rules, but they also have competition laws that regulate selective distribution systems, for example. So as you saw before in the Dior Evora case, there was a selective distribution contract that was being engaged. Now, that was not litigated, but let's look a little bit at how selective distribution systems are regulated under EU law. So in a selective distribution system, the manufacturer says, I will pick the retailers I like, and I will pick them on the basis of where the shop is located. It has to be located in a prestigious street. What other goods the shop sells, the staff that is in the store, such that the brand I have corresponds with the outlet that is being there, and I can also control how the product is displayed. Now, these agreements obviously restrict the number of distributors that are eligible to sell the medicines. So you have fewer distributors. And according to the Court of Justice's case law, these agreements restrict competition by object. They restrict competition by object because they prevent competition between retail outlets. So normally what happens is if Dior runs a selective distribution system, they will have one store per city selling that perfume. And so the purchaser of perfume you're not going to start traveling from Florence to Rome because the perfume might be cheaper in Rome. You're stuck with one outlet. And the Court of Justice's concern has always been that if there is no competition between retailers, that is a competition problem. I'll come back to why that might not be the case later, but for now, that's the premise. And so the court says we can only allow a manufacturer to impose a system of selective distribution under certain very specific conditions. And I've listed 3 of the more important ones on the slide. That the goods are luxurious, that you allow passive sales, and that some online channels are opened. So what is a luxurious product? Who knows? The court doesn't say, but the court knows when it is or isn't a luxurious product, but doesn't give us a very general definition. So again, there is lots of national case law that has engaged with this, particularly in Germany, looking at whether school bags are luxurious enough to be covered by selective distribution and so on. But the one I'm interested in is the second one. Passive sales are allowed. So if I have a system of selective distribution, I must allow parallel trade from other jurisdictions. I cannot prevent parallel trade. So if I have a system of selective distribution in France, I cannot confer the trademark to the French distributor and tell him, look, if anybody sells, you can get an injunction, because I must allow passive sales. But then if you look at trademark law, the owner of the trademark can prevent parallel imports if these damage the reputation of the brand. So there's a bit of a tension between the competition law rules, which says if you have a system of selective distribution, you must allow passive sales, that is to say, somebody abroad selling goods into the country where the selective distribution system is set, and the trademark laws, which say that you must allow parallel trade, but you can block it if it damages the reputation of the brand. So if you are a manufacturer and you put up a system of selective distribution in Italy, but you forget to put a selective distribution system for your products in Romania, then somebody from Romania can export the products, sell them lawfully in Italy, because passive sales must be allowed, and provided they don't damage the reputation of the brand, they're okay. But if they damage the reputation of the brand owner has a second attempt to protect himself by saying, I can protect these parallel imports because of the reputation of the brand. So in a way, what I'm trying to suggest is that the owner of a trademark can, notwithstanding the limitations of selective distribution, continue to protect the quality of his brand by using trademark law as a way of ensuring that the parallel trade that occurs in the country, in Italy in my example, does not damage the reputation of the brand. So the 2 rules kind of work together to protect the brand owner. On the one hand, he can set up a system of selective distribution, but must tolerate parallel trade. But using trademark rights, he can protect himself by allowing only some kind of parallel trade that does not damage the reputation of the brand. So the 2 systems, in a way, work together to protect the brand owner. From a practical perspective, the upshot of this is that if one wants to have a system of selective distribution, it is wise to have the same system in all 27 member states. Because that way, there is no chance of anybody having an economic interest in engaging in parallel trade, because each system, as distributors, will be provided with a territory where they know they are the only ones able to sell these products, and it's not economical for them to engage in parallel trade. And I guess the point I wanted to make with this is here, if you compare the way this perfume Black Opium is sold in Kruidvat and on the proper online store of the trademark owner, you can see why you don't want your perfume to be sold through a discount store, because it looks bad, but also because the prices are significantly different. So if you go to Kruidvat, you can buy the same product for half the price. So to a certain extent, you can understand why the Court of Justice wants parallel trade, because it understands that brand owners are able to effectively sell the products at twice the price if they're able to divide the common market. And so by facilitating market integration, the court believes it is acting to the benefit of consumers because prices are likely to go down, or at least more people can afford the perfume. Of course, from an economic perspective, this is a little bit strange. the reason people go to buy the perfume online and pay 132 euros for 50 milliliters is because they like paying 152 euros for 50 milliliters of this perfume. They want the exclusivity of, I can afford this. So to a certain extent, yes, price is one parameter of competition that the court protects, but what people are really keen on buying is not so much a cheap product, but a luxurious product for which price is not so important. So the court prioritizes price-based competition over sort of quality-based competition. Okay, now, from a legal perspective, what I try to suggest to you is that Article 101 and trademark laws work together in a way which, in my view, is coherent. So under Article 101, you can block passive sales. You cannot block passive sales. You're forbidden from preventing parallel trade. But the concept of exhaustion contains an exception by which you can protect your trademarks if parallel trade damages the brand. And so the two rules together cohere in giving the trademark owner a way of distributing their products that protects the brand. But from an economic analysis, things are a little bit different. Now, I've suggested to you, by allowing parallel trade, prices go down, and so the consumers are happier. But if you look at the two products in the case studies I've given you, Grundig and Dior, Grundig radios do not have a monopoly over the market for radios. Plenty of other radios you can buy if you don't like Grundig. Dior perfumes are not the only perfumes on the market. There's lots of competition among different manufacturers of different kinds of perfumes. I went online to do some research to see what Kruidvat sells, and there are literally hundreds of perfume brands you can buy. Radios, maybe the market is a little bit more concentrated, but they're both competitive markets. So when an economist looks at the cases on vertical agreements and finds that the court says a selective distribution agreement is restrictive of competition by object, an agreement which isolates the French market is a restriction of competition by object, an economist wonders why. If there is competition between different brands, prices will go down because the brand owner has to compete with other brand owners and prices fall. We don't need parallel trade to stimulate competition if there is competition between brands already. And this is something the Court of Justice ignores. So an economist, and I'm no economist, but every economist who reads these cases always tells me, is the court crazy? Because it is protecting intra-brand competition. It's saying retailer A should compete with retailer B, and they both should sell the same product. And from an economic perspective, the real competition between retailer A selling brand A and retailer X selling brand X. And it's the competition between A and X which drives prices down and benefits consumers because then they have more variety and choice there. The court says because the distribution agreement limits competition between retailers, that is the restriction of competition. It doesn't matter what the relevant market is. We don't need an economic analysis to even decide that there's harm to competition. So yes, maybe on specific facts, we could have a discussion whether, yes, it is a monopoly product and therefore preventing competition between two retailers is a problem because then the retailers could drive the monopoly price down. But in neither of these cases do we even know whether there is a monopoly in the product market. Point I'm making is if there is no market power, we shouldn't be worried from a competition law perspective about what the manufacturer is doing to the retailers. But under EU law, we worry because we're worried about trade between states. And so this is what some scholars call the market integration imperative. As soon as an agreement limits trade between states, that is inherently suspicious from a competition law perspective. Okay, now the second part of the talk. Till when do I?
45.
Okay, fine.
50.
So I'm going to talk a little bit about copyright law, and again, going back to the concepts of exhaustion. And again, we start with the 1980s with the fundamental case law and then move on to the present quickly. So this is a case, Coditel against Cinevogue Films, which is in two parts. They went to the court twice, but the facts are the same in both cases. So there's a film, and Cinevogue Film is conferred the exclusive rights to distribute these films in cinemas in Belgium. And he's also assigned the copyright over this film in Belgium. Coditel is a Belgian TV cable broadcasters who found that this film was available on a German station and transmitted the film from Germany into Belgium so that cable TV viewers could watch it if they had a subscription. And of course, what Coditel did ruined Cinevog's business model. Why would you spend 15 euros going to a Belgian cinema where you could just stay at home and watch the film on cable TV? And so Cinevog tried to block Coditel's attempt to export the film in the Belgian market because I have the copyright. So again, like Dior and Evora, the owner of the intellectual property right tries to block parallel trade. So the first time the case went to the Court of Justice was on the action taken by Cinevog, because they went to the Belgian court and they sought damages for lost profits as a result of the breach of copyright. And so the first question that the Court of Justice had to ask whether the Belgian law that gave Cinevog the exclusive rights to harm freedom to provide services was restrictive of internal market law. And the court says no. The right to be remunerated to show a film is the essential function of a property right. So Cinevog is exercising its intellectual property right in a legitimate manner because it is precisely the right to be remunerated for showing the film on the cinema that is the essential function of the copyright that is being conferred upon. And that showing the same film on TV harms the revenues of the right holder, and therefore he is legitimately entitled to insist upon their copyright. So the exercise of the right is legitimate because the essential function of copyright is being protected by this particular exercise of the right. And the court understands that the marketing of a film depends on different windows, right? So the first window is you put the film on in the cinema. That's where the owner of the film makes the most money because prices are very, very high. Once the film is not so interesting, then you put it on video cassette in the old days when there were video cassettes, then DVDs, second windows. And then the third window would be pay TV. And then after the pay TV is exhausted because people are not willing to pay for the movie, then you put it on free-to-air TV where you earn even less money. So to a certain extent, what had happened to this film was that in Belgium, it was still being shown in the first window, but in Germany, it had already moved to the second window because it was already on the pay TV cable channel. And so the second window, people were buying something cheap and selling it into the Belgian market and trying to undercut the profits. And so the court understood that the logic of film distribution meant that it was legitimate for the copyright holder to earn profits in the first window because that's what was still going on in the Belgian market and could not be undermined by parallel trade in the second or the third window. Okay. But then there was a counterclaim when the case went back to the Belgian courts. Just to clarify. The case is interesting, but we now maybe want to pay attention to the way in which the concept of exhaustion is dealt with in the Information Society Directive of 2001. This is the first directive where the legislator tried to codify copyright law. And so Article 3.1, member states shall provide authors with the exclusive rights to authorize or prohibit communications of the work. And importantly, 3.3, the rights referred to in paragraphs 1 and 2 are not exhausted by the act of communication to the public. So to a certain extent, if you litigate the Coditel Cinevog case today, it's much easier. There is no exhaustion in copyright. So when the film is shown in Belgian TV, that does not exhaust the right to insist on your copyright in another jurisdiction. Yes, the film is shown on German TV with the consent of the copyright holder, but every showing is a new thing. And so it's not as if there is a first sale in Germany, which then exhausts the trademark right, the copyright, and therefore you cannot insist on the copyright in Belgium. The right is now for each showing. And so while we have a principle of exhaustion, which works for physical products, if it's a physical product, once the product is sold on the market, it can then move freely across the EU. For copyright protected products, which are virtual, like a film showing, a showing of the film does not count as a first sale. There is no exhaustion. So in a way, the first litigation in Coditel Cinevog 1 is no longer needed because now the copyright holder simply says, well, look, the right is not it's not exhausted. So I can insist on my copyright without going to the essential function. But then there was a counterclaim by Coditel. Coditel says, well, okay, you can get an injunction, but the license by which you have exclusive rights to broadcast this in Belgium is anti-competitive. And so you may be entitled to rely on your Belgian law of copyright, but the contract that has been entered into between the producer of the film and Cinevogue is an agreement restricting competition because you're preventing parallel trade. You're giving one person the exclusive right to sell in Belgium. And if you go back to the cases we just discussed, the logic behind the claim is very clear. All the cases before, the court has always said absolute territorial protection is a restriction by object. And so you can understand why the counterclaim sounded logical and why the Belgian court decided, well, sounds right to me. On the other hand, the court in Coditel 1 had just said the essential function of a copyright needs to be protected. Am I going to then undermine what I've just decided about copyright law just because there's competition law? So again, the Belgian court was faced with a clash. On the one hand, the law of copyright protects Cinevogue. On the other hand, competition law appears to risk undermining the protection that has just been conferred by copyright. So what do I do? Hence a reference to the Court of Justice. And the court, of course, gives an answer which is clear but not so clear. So the court starts by saying we need to make a distinction between different types of copyrighted material. And I'm just going to give it to you more simply than the court does. Books and film, two different things. Books, once the author sells the book, the author is rewarded, the intellectual property right is exhausted. Once the physical copy of the book is transmitted to somebody else, that's it. But because films may be shown infinite times, we cannot have exhaustion in the first broadcast. And the essential function of a copyright must be that each showing is something from which I can get a fee for. And the court then explains the characteristics of the film industry, which I've just discussed before, suggests that for films, absolute territorial protection is not a breach of Article 101. So the court goes back on its case law and says, yes, as a general rule, free movement of goods, free movement of services, the internal market matters, but films are special. Because the way the license fee is calculated, because of co-licensing and because of windowing, we need to make sure that these distribution agreements continue to exist because they are pro-competitive, and therefore we carve out an exception. There is no prima facie harm if a copyright licensing agreement confers exclusivity for the broadcast of films. And all of this is said in a couple of paragraphs, and you really need to read between the lines to understand the reasoning, but that's the first couple of paragraphs. And so in these paragraphs, the court effectively says exclusive licensing agreements of copyrighted films are not anti-competitive, even if this means there is absolute territorial protection. But, paragraph 19, there may be an infringement in a specific case. So the court said there may be no restriction by object, but there may be a restriction by effect. And then it gives us a number of examples without elaborating when these agreements might actually become anti-competitive. And this I just reproduced paragraph 19. If the license creates artificial and unjustifiable barriers in the downstream market, if the fees are excessive, if the duration of the exclusivity is disproportionate, or if it prevents or distorts competition generally. So anything goes. Of course, it is then for the claimant to prove these anti-competitive effects, but it's not clear what the court means here. Let me just take a couple where I think things can be discussed. The fees exceed a fair return on investment. Now, under Article 101, you normally don't regulate the price at which goods are sold. In competition law, the only time you regulate the price at which goods are sold is in Article 102 when it's a monopoly selling products. And then we have rules about excessive pricing. Is the monopoly selling goods at a price which are unfair and unreasonable? And the test is very demanding, and the court demands a lot of evidence. But it's always in the context of a dominant firm imposing an anti-competitive price. So quite how you do that under Article 101 is not clear to me.
Except cartels.
But even with cartels, you don't check the price. In cartels, the cartel price is unlawful, but I don't care what the cartel price is. If a cartel agrees to increase prices by 1 cent, that is a cartel which is forbidden by Article 101. If the cartel agrees to increase prices by 20 cents, same problem. Maybe the penalty is different, but the offense is the same. Now, duration may be more interesting because it's the duration of exclusivity. So if I confer an exclusive right on a particular distributor for too long, that will foreclose market access to another distributor. So that one is more understandable because it fits into a theory of harm of foreclosure. I can legitimately sell my exclusive copyrights to one person for a while, but if I do it for too long, then maybe that prevents others. So for example, if I am a Hollywood major and I have a portfolio of movies, and I license these movies exclusively to one pay TV station for 20 years, then I kill competition in pay TV stations, or I significantly harm it because people normally don't subscribe to a pay TV channels unless there's some interesting stuff to watch. And so we know from earlier decisions in merger control that there are certain premium contents which the Commission believes drive the purchase of pay TV channels. And if you don't have premium content, you're foreclosed from the market. So maybe in a situation where you have an exclusivity agreement as a producer of copyrighted films, where you have a portfolio of films which are very important for the entry of rivalry in the downstream market, and if you appoint one exclusive distributor for 20 years, that forecloses market access. So that may be a situation where there may be an anti-competitive effect. What's interesting, if you go to the Commission decisions, these are all merger cases where there were mergers between different Hollywood majors in the 1990s. And there the court doesn't define markets, but says premium content is different from ordinary content. And so it doesn't say it is a relevant market, but it does acknowledge that the demographic of people buying pay TVs are of a particular age, of particular wealth, and their demand is for particular things. So if you have a pay TV channel for, the social life of pandas, and that's all you're showing, you're not going to make many sales. If you have a pay TV channel where you show ad infinitum all the Oscar-winning films, you're probably going to get a lot of subscriptions. So there is a distinction between these, which the court doesn't formally, the Commission doesn't formally speak on in terms of market definition, but that's where it's going. So premium content is a different market from non-premium content. Right. Let's just sum up where we are. Coditel gives us two lessons. First, the copyright owner can resist active and passive sales of a film because the broadcast of the film does not exhaust the IP right. But the claimant could always make a showing that some exclusive territorial licenses have anti-competitive effects. And it's this caveat that the Commission has become interested in. Because while in 1982, all we had was cinemas, cable TV, and some bad working video cassettes, there was no digital market for copyright content, but now there is. And the Commission in 2010 began a project of creating a digital single market. And of course, a judgment like Coditel is not very convenient for creating a single market because it is telling the copyright holder of a film that they can prevent parallel trade, which is the exact opposite of what an internal market is about. And so in 2017, the Commission did a market study on e-commerce trade and looked in particular at licensing agreements and observed that there are a lot of market failures. He says, today, we're not like in Coditel, online transmission of broadcast content, which is protected by copyright, is really important. It can stimulate entry, and it can promote established players based in one jurisdiction to enter other jurisdictions. Online transmission is really beneficial for consumers. And of course, the only way for the online trade to function is if the online trader have access to upstream content. So the Commission imagined a market where digital content is really useful to improve the economic welfare of the viewer, but also the economic welfare of a number of businesses that could enter to offer online content. And of course, Coditel 2 made it difficult to offer online content across the European Union because of the way in which vertical agreements were protected. And the Commission observed there are a lot of licensing practices which, in its view, are problematic from the perspective of creating competitive markets. And it identified a number of competition concerns. So I've listed them here. I'll just go through them briefly. Bundling rights to different media in one license. So often the holder of a copyright would say the same person who broadcasts these things online can then sell them on the mobile and on terrestrial TV. So these bundles of exclusive rights foreclose new entrants because the seller is not selling to a variety of businesses, but only to one business. Then we have geo-blocking, where the product is only available in one jurisdiction, the codital issue. Then the duration of licensing agreement comes back and the payment structures return. I'm going to focus on geo-blocking because that's what the Commission has done some cases on, and I think they're particularly interesting. There's one decision I'm not going to look at, which is the Football Association Premier League against Murphy, which is now of, I think, largely historical interest because this case, cross-border access to pay TV, is much more interesting. So again, I've tried to box out two different parts of the European Union. So red box, the UK, blue box, the rest of the European Economic Area. So in the UK, we have the Hollywood majors and also Disney entering into an agreement with Sky UK. And Sky UK sells broadcasts both online and via pay TV. And again, you see the bundling. So the Hollywood majors don't enter into a separate contract for somebody to sell online and for somebody else to sell on pay TV. They have an exclusive distributor in the UK that does both the online and the satellite communications. And Sky must block any passive sales. So if a French consumer approaches Sky UK and says, "Can I please subscribe to your online channel?" Sky UK must say, "No, you can't subscribe from the local pay TV provider." In other EEA states, the agreement between the Hollywood majors and Disney and Sky meant that the majors would agree to request that pay TV providers in the European Economic Areas do not make passive sales to UK users. So in France, Disney broadcasts through Canal+, and Canal+ agrees to only sell pay TV services to consumers based in France and not to sell this to consumers based in the UK or anywhere else in the European Union. So again, we have a situation very much like the previous cases of absolute territorial protection. And the Commission intervenes and says, we have a competition concern. And the competition concerns is that the consumer in France cannot buy a subscription in the UK. But remember that these things are copyright protected. And indeed, the Advocate General, the case, I'm not going to talk about the judgment in detail because it raises an issue which is not relevant. But the Advocate General observed at paragraph 44 that even without the agreement, passive sales would still be prohibited inasmuch as the licensees would not have the necessary rights to distribute works outside the relevant licensed territory. So if you're licensed to sell in the UK, you do not have a license to sell in France. And so if Sky UK were to sell a subscription to a consumer in France, then Canal+ would be able to get an injunction against Sky UK because Sky UK is breaching its copyright. And one of my colleagues, Pablo Ibanez Colomo, says, well, if paragraph 44 is correct, then the Commission's decision must be wrong, because the agreement does not cause the anti-competitive effect. Copyright law causes the anti-competitive effect. So his view on the left-hand side of the screen, copyright holders in the European Economic Area may seek an injunction to stop passive sales without relying on the agreement. Remember, there's no exhaustion in copyright, and therefore the agreement doesn't cause anti-competitive effects. So why does Hollywood Majors and Sky enter into this complicated agreement to prevent parallel trade when anyway the agreement doesn't cause the anti-competitive effects because trade between the UK and France is illegal because the copyright holder can protect himself in France? And the reason is a practical one. How can Groupe Canal+ identify the buyer of a Sky subscription? It's impossible. It doesn't have the power to do so. So whereas in the Dior Evora example, it was easy for the trademark holder to realize that Kruidvat is selling the medicine, the perfume in a bad way, here, Group Canal Plus cannot identify the purchasers. Maybe it can identify a decrease in sales. So if many French consumers all of a sudden start buying secretly subscriptions from Sky UK, then Group Canal Plus profits fall. But it still cannot identify who is buying. And so in a way, the agreement that was entered into between the Hollywood majors and Sky meant that Sky UK was acting de facto as an agent protecting the exports of subscriptions, because Sky UK was contractually forbidden from exporting into the French market. That's one view of the case. And so one view of the case is that the Commission doesn't have a leg to stand on because the agreement doesn't cause an anti-competitive effect. And if you think about it, the argument has some logic. But Advocate General Pitutela doesn't agree with Pablo Ibanez Colomo's conclusion that the agreement doesn't cause an anti-competitive effect. And this is explained in paragraph 79. Because he says, when the agreement between private persons extends beyond the core benefits which an intellectual property right is designed to confer, it may be an agreement that is restrictive of competition. So it goes back to the point, yes, the existence of the copyright in France is conferred upon the copyright holder. But the exercise of this right is what is being abused here. And so in the Advocate General's view, yes, copyright is relevant, but it is being misused. And this is the word that was used in Constant Grunding, the misuse of the copyright. So in effect, what the Hollywood majors and Sky and the other broadcasters in other European Union countries are trying to do is they're trying to rely on copyright as a basis to separate the market. And so it's a misuse of that right which can be challenged. So yes, we are not challenging the existence of the right, but we are challenging the way in which the agreements are designed such as to facilitate a division of the market. Even with this very sophisticated reasoning by the Advocate General, the decision of the Commission is still seen as a frontal attack on copyright law, because it really attacks the way in which national copyright laws are designed. And indeed, post this decision, the Commission has now gone back to the drawing board and say, we cannot really challenge distribution agreements in this way. We should think about legislation to facilitate the cross-border provision of copyrighted content rather than attack it indirectly in this manner. But I think the Commission's decision is correct, and one can illustrate that this decision is correct by looking at the last decision. I want to look at Valve and Steam. So the facts are a little bit complicated. Let me just take you through it and start with the left-hand side. These are video games that you play on the personal computer. And Valve or Steam had created a platform which was very attractive for video game publishers to sell their games through. And so you have a market where the publisher of games uploads the games on the platform, and then the PC user logs onto the platform to play the game. Then the question is, okay, I can log onto the platform to play the game. How do I buy the games? There are two ways of purchasing the games. One is to go on the platform and buy them. That is not interesting for today. What is interesting is the other way in which you can buy the games, which is either online or offline, and that's the right-hand side of the slide. So the publisher sells the games in three ways. One, he says, you can buy my games through the platform itself. Alternatively, you can buy them digitally through an online platform that just sells games, or physically from a store. You go to the store and you buy a CD-ROM or a key that allows you to play the game. Now, if you buy the games digitally or physically, the game is sold with an activation key. And the activation key is a key which is provided to the game publisher by Valve Steam. And the activation key only works in the country where you buy the game. So if you're a Polish gamer and you buy a game in Poland, you can activate that game in Poland. But if you take the same game and you go to your PC in Germany and you put the thing in, the activation key doesn't work. The idea behind this agreement was that consumers in sort of countries that joined the EU from 2004 onwards have lower purchasing power than consumers in the older member states. And so these games were sold at different retail prices depending where you were. If you're in Germany, the games are more expensive than if you're in Poland. And in order to prevent parallel trade, the activation key was set up so that the game would only work in the country of purchase. Again, you can understand why the Commission got interested, because this prevents passive sales, blocks parallel trade. And again, obviously the case was decided, agreement restrictive of competition and so on and so forth. And Valve's team have obviously read the work of my colleague Ibanez Colomo, because they said, hold on, the agreement merely reflects non-exhausted copyright in the distribution of video games. So the agreement does not cause the anti-competitive effects. Video games, like films, are not exhausted on a first sale, because you can play the video game only once at a time, and therefore there is no exhaustion. The agreement does not cause an anti-competitive effect. Yes, I tried to seal off the market, but I didn't need to do it, kind of argumentation. And the reason I bring this Commission decision to your attention is because the point was not discussed in the General Court when the case was appealed, but at paragraphs 348 to 355, you get a really nice explanation by the court as to why this argument doesn't work. The argument that the agreement does not cause anti-competitive effects because anyway copyright would prevent passive sales anyway, so it's not my fault. You cannot attribute the restriction of competition to me, because the restriction of competition is the result of the law of copyright. The Commission starts paragraph 351 by saying passive sale restrictions are incompatible with the completion of the internal market. So, as a general rule, we need to be careful about anything that restricts parallel trade. Secondly, the interpretation about what you can and cannot do under copyright law is not for the Commission. It's for the national courts to decide, and not for the parties to the agreement to decide privately, or for anybody else. So we're not competent to decide if there is or isn't exhaustion. And the court observes that there were different judgments from national courts as to whether PC games are or are not exhausted as a matter of copyright law, and that's a different legal question from the competition question. So, and this goes back to a point that the court has made many times, you cannot use an anti-competitive agreement to prevent illegal conduct. So it cannot be a good justification. There's case law on this where, for example, a manufacturer of a very dangerous product said, I will not sell this product, it was a nail gun, unless the buyer of the nail gun also buys the nails I make for the nail gun because of health and safety. I want the nail to be safe, and so I will design the nails carefully so they fit into the gun, and no other person should be able to sell these things. And the court said, it's not up to you to regulate who can sell on the secondary market for nails. If your rival's nails are dangerous, there are laws to prevent them from entering into the market. There is enforcement about health and safety legislation that would prevent the sale of unsafe nails. There are standardization rules that prevent the entry of dangerous products. It's not for the dominant firm to regulate market access. And the court says the same thing here. You cannot use an agreement to fortify or police what you think is the right approach to interpreting copyright law.
What's Budapest banks also, no?
Yeah, Budapest Bank, yeah. Yeah, the case law on this is well established. But what's interesting, the court imports this case law into here and says it's the same for copyright. You cannot use competition law to put your interpretation about what is copyright law onto an agreement. And then paragraph 353, just one point, is interesting because the court says, of course, if a retailer engages in passive sales, he runs a commercial risk. Indeed, he runs a legal risk that he may be sued for damages by the copyright owner. But this is just a risk that you run. And it is up to the distributor who takes that risk to decide whether or not to take it. You cannot forbid him from taking that risk. Now, if you go back to the Canal Plus story here, if the agreement is now banned, but if Sky UK wants to take the legal risk of selling subscriptions in France, and then it gets caught and pays damages, that is its own risk. You cannot let the parties to the agreement subdivide the markets because Sky UK's sales in France are illegal. Yes, they're illegal, but competition law is not designed to police what should be policed either by the private actor or by a public regulator. And I think this decision is interesting because it kind of explains the logic that the Commission was following in the pay TV story line of case law. And so I think it's an interesting point, but yeah, you had a question. So the Commission issues the decision. So if you look at the way the decision is done is the Commission runs its case and then it looks at the counter arguments. If you look at the Commission running the case, they don't even think about copyright. They just say, look, we have an agreement whereby the key prevents a German PC gamer from buying the game in Poland. The technology means that he cannot play the game if he buys it abroad. That's enough. The case is closed. Then it's Valve that says, hold on, maybe it's not so easy. But this argument is simply saying the case is not restrictive of competition at all. So if the Valve's argument had been successful, it would be successful whether there was an object or an effect case. Because the point was simply the causal connection between the agreement and the effect is not there. Now, as I said, the causal test is different in the two. In object, it's obvious, so it's just about capacity. In effects cases, it's more about showing but for, then the market would have looked differently. So you do a more complicated causation test. But this argument would kill both an effect or an object case because you'd say, I cannot possibly harm competition if the law forbids the conduct that I'm trying to ban. Right. But what's interesting is that the court says it doesn't matter what the law says. Somebody could still decide to break the law. And in a way, what the court says is right, because if you look at the many competition law cases arise because somebody's breaking the law. So the postal services in Europe were liberalized because of somebody called Paul Corbeau, who in 1990 decided to offer an alternative to the Belgian postal delivery service by having a bicycle and telling businesses, you need to send a letter in Brussels from office A to office B, give it to me and I'll fly across and it will be delivered in 20 minutes. And then the Belgian government took a legal action against Corbeau and prosecuted him for committing a criminal offense because he was doing that which had been exclusively given to the Belgian post office. And then the Court of Justice says, well, but look, freedom to provide services, freedom of competition, you cannot reserve monopoly rights. So acting illegally for the Court of Justice is a good thing. You're a hero if you break national law because the national law may be that which actually hampers the development of markets. So maybe you can understand why the court wants to encourage risky behavior on the part of parallel traders because that would liberalize markets. Sorry, that bit weird. So the question I have now is, and I want to leave you with this thought, is the court is basically telling us from, in Coditel 2, it said absolute territorial protection, geo-blocking of copyright content is normally lawful, except in some circumstances where you can say it's harmful. That was 1982. Then in 2017, the Commission became interested and said, well, wait a minute, we want a digital single market. We don't like Coditel. Let's run cases against geo-blocking of copyright content. And now we have the decisions in pay TV cases, which have been withdrawn for reasons which have nothing to do with copyright, but more with the nature of the decision itself. And then Valve Steam, which tried to integrate the market. So the question is geo-blocking ever lawful? So if you go to the bottom, Coditel 2, I think that's a clear case where you can still justify things. So if there are cinema windows, you can probably still prevent parallel trade. So if it's a French film, which in France is shown in cinemas for 6 months because the French love this film, but it's not particularly popular in Hungary, and in Hungary it goes straight to TV, then you can block the transmission of that film from an online channel broadcast in Hungary into the French market because the French window is still open. So I think Coditel 2 is still correctly decided in so much as you can legitimately block certain forms of parallel trade. In Valve Steam, one of the other arguments which was made by the parties to the agreement is that geo-blocking would allow for lower prices in states with lower purchasing powers. And so actually, the reason why we're dividing the market is to benefit poor consumers. If we are not allowed to geo-block and we want to make profits, what's going to happen to price? We're going to raise the price in Poland and lower the price in Germany, because that's the only way we're going to maximize sales. So actually, the price differences between jurisdictions are legitimate price discrimination because we are trying to sell as many games as possible to gamers across the union. And if we harmonize the prices, then the countries where the prices are lower will pay a higher price, and the richer countries will actually pay a lower price. And this is true. I think yesterday one of the speakers talked about a case called United Brands, which is about bananas. And there too, the Commission said price discrimination is unlawful, and United Brands said, okay, we will bring the price up in poor member states, Ireland, and down in rich member states, Germany. So the agreement was actually regressive because it harmed the poorer consumers. Now, the Commission says this argument is plausible. So a defendant can say, I can legitimately geo-block because of price discrimination reasons, which are legitimate because I give poor consumers a better price. But the burden of proof is on the defendant to demonstrate that the agreement is necessary to achieve these lower prices, and that had not been demonstrated. So it's a nice argument in theory, but I'm not so sure what evidence can be brought to demonstrate this. And the burden of proof when you want to justify anti-competitive conduct is on the defendant, and it's difficult to see how that can be discharged on the facts of the case, at least. And then finally, Group Canal Plus. Now, why was this case controversial? The case was controversial because in France, film financing works in this way. If you are Canal Plus, you have to pay some of your profits into a fund which funds French films. And so both the French government and the French broadcaster made representation to the Court of Justice against the Commission's decision, not so much for the technicalities of the case, because they said, look, this is killing our business model. If we cannot make sales in France because the French consumers are going to start buying pay TV from other jurisdictions, we're going to have less money. If we have less money, we cannot pay into the fund to make French films, and therefore you're damaging our national culture. And then they refer to the treaty, and the Treaty of the Functioning of the European Union says culture is important, and therefore we must make sure that union law does not harm the development of national cultures. So we have a tension, the French government argued, between competition and national cultures. The court never really answers the question, but I think it's an interesting one to debate in terms of can you justify restrictions of competition in the name of culture? And there is indications from the court's case law that the answer is in the affirmative, but the court has not yet come to a clear standard how to trade these two things off. Okay, I think I've exhausted my time, but thanks for the questions and for your attention.